not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence. So you're not going to commit to follow this order. You won't commit to follow this court order.
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
What you just watched is not about sympathy, politics, or emotions. It's about the Constitution. Representative Dan Goldman didn't walk into that exchange to defend a person. He walked in to defend due process, the separation of powers, and the rule of law, and that distinction matters more than people want to admit. What stood out immediately is how calmly and methodically Dan Goldman anchored the entire conversation in basic civics. He didn't argue hypotheticals. He didn't excuse alleged criminal behavior. He asked one simple question: who gets to decide what the law is? And the answer, whether people like it or not, is the judiciary. If you care about constitutional accountability, this exchange should concern you deeply. Before we get into the full breakdown, make sure you like this video, subscribe to Congress Lens, and turn on notifications so you don't miss our deep dives into what's really happening in Congress. Now let's get into it.
I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So so I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that, notwithstanding your statements under oath here today, that Mr. Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence. So you're not going to commit to follow this order. You won't commit to follow this court order.
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
so
sir, and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately. Why is your opinion better
We had
and
two
have more authority than the Supreme Court?
investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
No,
is
no, no, no.
investigators and law
That is
enforcement
you
officers
making that
and the case they
determination.
built against him. If you don't
The
trust our law
court
enforcement
has
officers
considered all that.
and
The judge has
investigators,
considered all that,
then
Madam
who do you
Secretary.
trust if you
And
don't
if you would be
trust judges?
quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court order
who has terrorized
says
people
that
in
you
traffic
must take
with human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for
sure it
due
is to my
process.
constituents as
And
well.
that's under the Constitution.
The gentleman's
and you
time
should
has
fight too for due
expired.
process.
The gentleman's time has expired. I now recognize.
After watching that entire exchange, one thing is crystal clear. Representative Dan Goldman is absolutely right, and the pushback he received proves exactly why his argument matters. Dan Goldman was not arguing that Abrego Garcia is innocent. He was not disputing allegations. He was not defending MS-13. What Dan Goldman was doing, repeatedly and deliberately, was drawing a bright constitutional line between allegation and adjudication. And that line is not optional. From the very beginning, Dan Goldman established the foundation. The Constitution gives the power to interpret the law to the judicial branch, not to executive agencies, not to political appointees, and not to law enforcement officers making unilateral determinations. That point alone dismantles the Secretary's position. When the Supreme Court rules 9-0 that due process was denied, that is not a suggestion. That is not a debate. That is the highest court in the country issuing a binding judgment. Dan Goldman correctly called out the absurdity of an executive official sitting under oath and effectively saying, "I disagree with the Supreme Court." That's not how the system works. What made this exchange especially troubling was the repeated attempt to replace judicial findings with law enforcement assertions. Dan Goldman rightly pushed back on the idea that accusations, no matter how serious, can substitute for due process. If allegations alone are enough, then courts become meaningless. Judge Wilkinson's quote was pivotal, and Dan Goldman used it precisely as intended. The judge did not say Abrego Garcia was innocent. The judge said it doesn't matter, because due process applies regardless. That's the core principle of constitutional law, and Dan Goldman refused to let that be distorted. The Secretary's refusal to commit to following the court order was the most alarming moment of the exchange. When Dan Goldman asked a direct question, "What steps have been taken to comply with the Supreme Court's directive?" there was no answer. Just deflection. And then came the emotional attack, accusing Dan Goldman of fighting for a terrorist. That accusation failed, because Dan Goldman never took the bait. Instead, he stayed grounded in the Constitution. He made it clear that defending due process is not the same as defending a person. It's defending a system that protects everyone from unchecked government power. And that's the part critics don't want to talk about. If executive officials can ignore court orders in this case, they can ignore them in any case. If allegations alone are enough today, they will be enough tomorrow, against anyone. Dan Goldman understood the stakes. He respected the courts. He respected the Constitution. And he exposed a dangerous mindset, one where executive authority is treated as superior to judicial review. This wasn't about politics. This was about whether the rule of law still means something. And on that front, Representative Dan Goldman was unequivocally right. That's why moments like this matter, and why Congress Lens exists. If you want more clear-eyed breakdowns of what's really happening in Washington, stay tuned.